Did you know that having bodily contact with someone could be an offense depending on how this happens? Let's look at what the tort of battery is about. At common law, battery is a tort falling under trespass to the person, entailing unlawful contact which is directed and intentional or reckless, or in some other countries such as Australia, negligently and voluntarily bringing about a harmful or offensive contact with a person or to something closely associated with them without legal consent. Battery involves an actual contact which may be by one person, the tortfeasor, of another with or without a weapon, or may be by an object brought about by the tortfeasor, an example being driving a car or causing a car to hit someone. We must note that no actual damage or injury need be proven. Only proof of contact with the appropriate level of state of mind needs to be made. Now, what are the elements of battery? The elements of battery are the directness of the act, the voluntariness of the act, the state of mind of the actor, the physical contact, the lack of consent, and the positive act and not omission to act. Let's look at the explanation of all these elements. 1. The directness of the act. The principles are as follows. Trespass lies where the injury is immediate from an act of the defendant, or if the injury results from the direct act of the defendant, then it is trespass. This was held by Nars J. and De Grey in Scott versus Shepherd. Also, where a person causes an act knowing that it will produce an effect, the act of an intermediary who acts for his defense does not become a new act. The act remains that of the originator. This was held in Ellenborough in Covell versus Lamming. Also, where injury is the immediate result of an act of force done by the defendant, the remedy is in trespass, where the injury is only consequential to the act of the defendant. This was held in Ellenborough in Lyme versus Bray. Now to the second element, voluntariness. The principle is that trespass lies when an injury inflicted results from an instrument or medium controlled by the defendant. Trespass lies when an injury inflicted results from an instrument or medium controlled by the defendant. Where an instrument is used, the instrument is regarded as a passive instrument of the person in control. This was held in Gibbons versus Pepper. Thus, voluntariness is about controllability, the tortfeasor in control of the act, and not about willingness. Let's move on to 3, state of mind. The principles are as follows. Trespass to a person is restricted to intentional acts. This was held by Lord Denning in Letang versus Cooper. Also, trespass to a person does not lie if the injury to the plaintiff was caused unintentionally and without negligence. And in the course of action for trespass, the burden of proof lies with the plaintiff. This is per Diplock J in Fowler versus Lanning. Also, Stable J in Morris versus Marsden also stated it is immaterial in an action for trespass that the defendant knew that what he was doing was wrong. Also, Kroom Johnson LG in Wilson versus Pringle stated that in an action in battery, The plaintiff must only prove that the defendant did the act intentionally and not that the defendant intended that his act cause injury. Lastly, in Livingston versus Ministry of Defense, Hatton J. stated that in an action for battery, it is not necessary to show that the plaintiff was the intended target of the act. It is only enough to show that the defendant intended that the force was meant to be applied to another person. Now, moving on to the fourth element, physical contact. The principles are: 1. Physical contact does not necessarily mean person to person, but may be with the aid of a tool or weapon. This was highlighted by Higgins L.J. in Breslin versus McVitt. Also, injury should result either from personal contact or through the medium of an instrument controlled by the defendant. This was held in Fagan versus Metropolitan Police Commissioner by Lord Parker. Holt C.J. in Cole versus Turner, in stating the manner of the physical contact of touching, made it known that the least touching of another in anger is battery. But should the touching be hostile before it can be trespass? Relying on Cole versus Turner, the Court of Appeal answered yes in Wilson versus Pringle. But the view was rejected by the House of Lords in Collins versus Wilson, and Lord Gough in Re F affirmed the position stated in Wilson versus Pringle. 5. Lack of consent. The principles are that there are 3 types of lack of consent. Now, there is a lack of express consent, there's a lack of implied consent, and privileged contact. Establishing any of these will suffice depending on the nature of the act done. For lack of express consent, see Christopher versus Beer and Nash versus Shine. On the lack of implied consent, consent may under appropriate circumstances be implied. This was by Kroom, Johnson, LJ in Wilson versus Pringle. Now to some explanations on these. With consent in respect of battery, it is enough if the plaintiff consents to the nature of the act. The law does not require informed consent. This was held by May J. in Cratesfield, the Jacob disease litigation. Also, true consent requires consent to both the nature and quality of the act. Consent given on a mistaken belief is void. This is held by Lord Justice Rose in R.V. Tabassum. On the onus of proving lack of consent, in Lloyd of London versus Sealera, McLachlan J. laid the principles as: in all intentional tort actions, the onus of proving the defense of consent is on the defendant. Under privileged contact, it was held in Whiffin versus Kinkard that there is a presumption in general of consent to all non-hostile contacts merely incidental to living in a community. So, in Coward versus Badley, Justice Martin stated, a touch to draw one's attention is not battery if done non-hostilely. Thus, an action in battery does not lie unless it appears that there is no actual or apparent consent. That is in Guaro versus United States. Now 6. Positive acts and not omission to act. The principle on this is: trespass requires a positive act from the defendant. A person does not commit trespass if he is only passive and does not act. Again, trespass requires a positive act from the defendant. A person does not commit trespass if he is only passive and does not act. This was established Denman in Innes versus Wiley. So in conclusion, this is the end of our first episode. We hope you learned a new thing today. You can ask all your questions in the comment section and they will be answered. But more importantly, don't forget to like, subscribe, comment, and share to everyone.